Hello, everyone. The independence of the Election Commission of India is engaging the attention of the Supreme Court now. A constitutional bench of the Supreme Court has reserved judgment on petition seeking an independent mechanism to appoint election commissioners. So in this context, we are having a discussion with Dr. S.Y. Quraishi, who was the Chief Election Commissioner of India from 2010 to 2012. Thank you so much, sir, for joining us.
Thank you.
So one of the issues which is engaging the attention of the court is that Article 324 of the Constitution, it provides for an independent election commission of India. And Article 324 also says that the appointment of the election commissioners should be in accordance with a law which is to be made by the parliament. But even after more than 70 years of the commencement of the Constitution, the parliament is yet to frame a law for laying down the procedure for appointing election commissioners. So it is in this context that the court is contemplating whether it should step in to fill in that legislative gap and should issue guidelines for an independent mechanism. So there have been so many suggestions have been placed before the court. One suggestion is that there should be a collegium comprising the Prime Minister, the leader of the opposition, and possibly the Chief Justice of India, who should be appointing or recommending persons for appointment as election commissioners. So in this context, in the light of your years of experience as a civil servant as well as the Chief Election Commissioner, do you think that the system of appointment needs reforms and a revamp?
Absolutely. That is what we have been saying. I have been saying, I've written many articles, I've spoken on many occasions that the most powerful commission in the world has the most defective system of appointment. Unilaterally, the executive of the day appoints an election commission, whereas all over the world, there is a wider system of consultation. In many cases, there is even parliamentary scrutiny. In some countries, there is a live interview of the candidates on the live national television. So in such a situation, this system needs to improve. That's what we have been demanding as CEC. Although I was a beneficiary of the old system, I wrote to the government, and before me, several of my predecessors wrote the same thing to the government. And time has come when hopefully this bench will decide that there will be a collegium. We are already familiar with the collegium system. We have collegium for CVC, CIC, even director of CBI. Although director of CBI is not even a statutory body, he is just a head of a department like director of agriculture. But because he performed this very sensitive function, that's why the Supreme Court had decided that there should be a collegium. So election commission, which the constitutional body performing the politically sensitive function, surely deserves to have a collegium.
So in the present ongoing proceedings before the Supreme Court, the union government has taken a stand so as to oppose any sort of judicial intervention. The government has taken that it is a matter which is completely for the parliament to decide, and the judiciary should not be interfering in the appointment of election commission. And the government has taken a stand that the election commissioners, there is nothing on record to doubt the credibility of election commissioners. And it is not a matter for the court to step in. This has been the stand of the government. So what do you think about the court interfering in this matter?
No, this is the court has not interfered so moto. There is a PIL before it. Right, and right. In fact, there have been PILs before that also. And actually, Supreme Court has come into it too late. The PIL was filed in 2018. It has taken 4 years for the Supreme Court to constitute this bench. And Supreme Court has every right to question why is it that under Article 324 bracket 5, when a law was to be made, prescribing the service conditions and recruitment procedure, etc., why it has not been done so far. Of course, let Parliament pass the act, but why has Parliament not done it for the last 70 years? And the court has every right to ask. And Parliament so moto doesn't act. It is the executive which initiates the proceeding in Parliament. So it is the failure of the executive, successive executives.
So during the proceedings, the court has also scrutinized a recent appointment made to the election commission as well. And the court has raised several questions why the appointment was made in a very hasty manner, and what was the criteria followed by the government in finalizing or shortlisting the names. So from your experience, what do you think, what are the guiding factors which the government follows while choosing persons for appointment as election commissioners?
So obviously it is entirely the choice of the executive. The Prime Minister chooses somebody, right to the President to appoint, and after President's approval, the notification is issued. So that's what it is. And this case is absolutely incidental. This was not on the list, but suddenly it happened. And in fact, it seemed that the government has been caught on the wrong foot. The post was lying vacant since May. There were two states going to the poll, two states, Gujarat and Himachal, and the government felt no urgency at all. Whereas elections to two states are an important matter, the government did not find it necessary to fill the vacancy of the third member. And suddenly in 12 hours, if they do it, so obviously the question will be raised, and that is what the court has asked.
So the obvious question or the perception which the public will be having is that in the absence of any guidelines or any parliamentary framework, the government will be picking up persons who might be towing the government's line or who might be favoring the executive's interest in the election.
Well, that is the allegation. That is what people say always. Although for the last 70 years, government of the day has always appointed the CECs or ECs, and except for one or two, all of them have conducted themselves very well. They have acquitted themselves with honor, and as so much so that the Election Commission of India has acquired worldwide reputation. India's elections are considered model elections, and Hillary Clinton went to the extent of calling it the gold standard. So, despite the faulty system of appointment, because the fault is, although the CECs have been conducting themselves well, and we hope that they will behave well in future as well. But hope can never be a strategy. There has to be an institutional mechanism, and there has to be institutional check. So, and there are two things which we have been suggesting. One is the appointment system, that the election commissioner should be appointed through collegium. After all, we are familiar with the collegium system. It is working pretty well. Nobody has ever raised a question about the judgment of the CVC or the CIC, because the wider consultation took place. Leader of opposition was involved, and if the leader of opposition is involved in this decision making also, at least the opposition parties will not be able to raise a finger against the incumbent EC or CC, because they were party to the selection process. Therefore, not only it will be a fair and neutral system, it will appear to be neutral. So that is the basic principle of law.
So if there is a system, at least a perception of independence will be there, and the public will be, that will boost the public confidence in the system.
Exactly. You know, that's what I said. When I was in office, I said it in some TV interviews. In fact, I still remember one interview by Karan Thapar. I said if a leader of opposition was also signatory to my appointment, I would have felt much stronger, better, much more confident. So, not that I did not act with fairness. You know, there was law minister of the land belonging to the same party which appointed me, but we censured him. We took action against 2-3 other ministers. So therefore, but that is our individual style of management and our character. But everybody may not have the same attitude.
Right. So even the court was mentioning the name of Mr. T.N. Sheshan, and the court said that people like T.N. Sheshan comes only once in a while, and we need to have strong people who are not yes men of the government and who can even stand up to the prime minister even. That's what the court was already saying. Another issue which the court was highlighting was the comparatively short tenure which the CECs have been having over the past several years, at least for the past at least 10 years or so. So the court was saying that as per the 1991 Act, although it contemplates a tenure of 6 years, all the recent CECs, they have been having short tenures. So do you think that there should be a fixed tenure for the CEC, a longer tenure?
Well, I think the court has not really appreciated this point because, they have not yet gone deep into the issue. Since 1993, it's a multi-member commission. Before that, there used to be only one officer called the CEC. He was appointed for 6 years and he served for 6 years. From 93, you are first appointed as election commissioner. And after 3-4 years of service as election commissioner, you are elevated to the post of CEC. So the combined term is always between 5 and 6 years. So we have to look at the combined term. So obviously, and at 65, you have to retire because that is the other provision that it is a term of 6 years or 65 years of age, whichever is earlier. So since mostly the retired secretaries to Government of India are appointed, and that is at the age of 60, and they have, according as per the provision of the law, they have to retire at the age of 65. So in most cases, they are retiring in 65, which means 2-3 years or 4 years of EC and 1 or 2 years as CEC. I was there for a full 6 years because I had 1 year to retire when I was appointed. So I was appointed at 59. So that gave me all 6 years. For 4 years, I was EC. For remaining 2 years, I was CEC. The combined tenure was 6 years, 1 month short of 6 years. So that's the law, and that is otherwise working okay. Otherwise, do we expect a deputy secretary to Government of India to be appointed as CEC? He only will have a full 12 years then, 6 years as EC and then 6 years as CEC, because then there's a 65 limit will not apply to him. So obviously it requires some seniority, some maturity, and it has to command respect of all the bureaucracy countrywide, which is why a former secretary to Government of India is the best choice. For another reason also, the question was raised, why only the IAS officers? So it has not only been the IAS officers, there have been 2 law secretaries, there have been 2 IRS income tax service officers. What is required is a relevant experience. We can't have judges. Pakistan used to have judges and it used to be a disaster. They may be brilliant in law, but they know nothing about election administration because election is an administrative job. And IAS officers have done it all their life. I was a presiding officer of a single booth. Then I was returning officer in Vidhan Sabha and Lok Sabha in many elections. Then I was observer in many elections, and all the officers who have been appointed so far have that kind of experience. Therefore, otherwise, although no qualifications are laid down anywhere, government can pick up anyone, but they have been appointing only civil servants, which is a good thing. Even the present government hasn't tinkered with that, and they have also been elevating the senior most to the post of CEC. They have not tinkered with that either, which is a good thing. But it is good, it is important to have an institutional check. Let there be a law. Let there be some rules very clearly laying down the procedures.
So do you think that there should be a dedicated service for election commission for something like an election service or something?
Because not at all, not at all. That's an absurd idea because the election commission has permanent staff of less than 1,000. But on election day, we have 12 million people, government servants conducting our election. So you expect a 12 million staff of election commission doing nothing except for 3 days, 3 election days. So the present system is absolutely fine, working fine. And these 12 million are trained to conduct elections, and they are expected to deliver zero error election, which they have been doing year after year. That system is fine. Dedicated service is not a good idea at all.
Right, sir. And according to you, what are the other reforms which the election commission should have for us to have a more efficient system?
We have been talking about the appointment system, but the removal of the CEC is stopped by the constitution, because once appointed, a CEC cannot be removed except through impeachment, like a judge of the Supreme Court. Now, as you know, impeachment requires a 2/3 majority in both houses of parliament. Nobody has ever been impeached. So removing an incumbent is almost impossible. So that is what gives him a feeling of independence and autonomy. He is not scared of the executive. Same executive which appoints him, after appointment cannot touch him. So now the same protection, the same logic should extend to the other two commissioners. It used to be a single member commission till 93, and he was protected from removal. Now this protection was available not to an individual but to an institution. The institution of the Election Commission headed by the CEC. Now it's a 3-member commission. Obviously, this protection should extend to all 3. Otherwise, what happens is, although all 3 are equal in rank, pay, and voting right, so the 2 commissioners who consider themselves on probation, because they can be removed very easily, so they consider themselves vulnerable. They feel they are on probation, so they may be trying to please the government, and they are not sure that they will be elevated to the CEC, because this is also the discretion of the government. Although the government has not yet violated it, but it can if it will feel like. Therefore, these 2 things should be made very clear, that once appointed, even the commissioners cannot be removed except through impeachment, and the elevation to CEC will be automatic by seniority, as happens in the case of the Chief Justice of India. The senior most judge of the Supreme Court gets appointed. The government has never tinkered with it. Indira Gandhi once did it, and till today people criticize her. So 50 years later. So therefore, we have the systems already in other institutions, and that needs to be extended to Election Commission.
Right, sir. Right, sir. So thank you so much for sharing your views on this topic. Thank you so much.
Thank you very much.